That's always a good barometer as to whether a company should have a post-employment covenant restricting someone's ability to compete once they leave.
And so, Tim, I think you mentioned that there has to be certain, I guess, reasonable restraints as to geographic or temporal scope of these agreements. Can you talk a little bit about what makes an agreement reasonable as to, its range and its length?
Sure, Mike, and it really depends on the circumstances, and in particular the circumstances of the employee. A lot of times what I see is that courts will not want to enforce a restriction against an employee that goes outside, if we're talking geography, goes outside the geographic area where they work. So for instance, a salesperson who may work in the Metro Detroit area where I live, a court may enforce a non-compete or non-solicitation restriction against that employee that restrains them from competing in Metro Detroit or soliciting clients in Metro Detroit. But if an employer had a non-compete that said they were not allowed to compete at all in the entire state of Michigan, where the employee never worked outside of Metro Detroit, then the court would likely not enforce that portion of the restriction and do what we call blue penciling, which is in many states, courts are permitted to narrow the restriction to make it more reasonable in the court's view. And as to time, generally, again, that has a lot to do with the circumstances of the case. Some states now are enacting laws that prohibit restrictive covenants like this, non-competes, non-solicits, that extend beyond 18 months. Typically, a good rule is that anywhere from 1 year to 2 years will be enforceable, absent a law to the contrary. And if you get much beyond 2 years, then that's when you really run into the danger zone.
Are there any states that prohibit non-compete agreements?
There are. California.